The Independent Office for Police Conduct has now said that the firearms officer who was cleared of murder will now face a full misconduct hearing for his actions, meaning his whole career could be in tatters and obviously he'd lose his job if that hearing finds against him. You might recall this was reported where the firearms sergeant took the split-second decision to shoot the man driving the vehicle because he was driving an Audi that was linked to a prior firearms incident, and instead of stopping the vehicle, he instead decided to ram the police cars, and this officer said that he feared for his own and his fellow officers' lives. Other officers said that they were split seconds away from taking the same decision, and if he hadn't have done so, they would have done so. This investigation by the original investigation by the IOPC then led to the Crown Prosecution Service charging this officer with murder. This trial was in October 2024, and he was unanimously acquitted by the jury in under 3 hours. Now, many people disagreed with that decision, but it was a jury decision nonetheless, and he was unanimously acquitted of all charges. After the trial, restricted information then came to light about the driver of this vehicle's criminal history. He was identified as being the member of a gang. He had prior convictions for violent offences, including knife crimes and possession of imitation firearms. Additional evidence suggested that he was also involved in a shooting just several days before his death. The Assistant Commissioner of the Metropolitan Police said he made strong representations that this officer should not face any further action due to the extensive evidence tried and tested at the Crown Court and the not guilty verdict returned by the jury. Despite that, the IOPC has said that they've examined all the evidence and views of the parties and that they will commence a full disciplinary hearing. Remarkably, the IOPC website says that after a thorough review of all the evidence, the case continues to meet the threshold for which this sergeant should attend a misconduct hearing. At the end of the investigation into the fatal shooting, they say, we determined that there was sufficient evidence to indicate that he may have breached the police professional standards regarding his use of force, and therefore had a case to answer for gross misconduct. Now, just to answer one or two of your questions before I move into a couple of other things, I'll talk about the use of self-defense. Now, on that note, I have a couple of videos, quite extensive videos that I've done here on this channel on the use of self-defense, which includes the use of weapons and all sorts of things. They will be available in my members section. You'll see the join button next to the subscribe button down below, so please do hit that subscribe button while you're down there, but do consider joining the channel because they take a lot of time and research for me to do those videos. They will be extensive. They're sort of 30 or 40-minute videos in length, talking about the use of self-defense, proportionate force, the use of weapons, and so on. So please do consider joining as a member to the channel. That will support me, and there'll be lots of other types of content there. You can let me know what kind of content you want as a member. I can see your questions, your requests, and I can do video answers that are members only. So please do consider joining as a member. So let's talk about one or two of the very broad questions here. Now, any use of force must be justified. Unlawful use of force is the use of force that is not justified. Now, it is very similar for police as it is to citizens. It's even more restrictive for police. In fact, there was a recent case that said if a mistake has been made, it must be a reasonable mistake to make. But that is a more stringent test than that is placed upon civilians. Normal civilians, if you make a mistake, it will be taken into consideration whether or not it would be a reasonable mistake to make in the circumstances you believe them to be. But that is not an absolute requirement. But the recent test for police officers, again with the IOPC, concluded that it needs to be a reasonable mistake if a mistake has been made. But otherwise, the use of self-defense is broadly the same. It needs to be necessary to use force, and then the use of that force must be proportionate in the circumstances that you genuinely believe them to be. Now, that might be anything up to and including lethal force. So some people might mistakenly, with respect, believe that fatal force is not justifiable in any circumstances, but in fact it is. Fatal or lethal force is justified if you believe that there is a genuine threat to your life. But again, it must be necessary, and then the balance must be proportionate based on those circumstances that you genuinely believe them to be. So it's a two-part test. It's a subjective test as to the circumstances you believe them to be at the time, and it's an objective test as to whether the force used in those circumstances was reasonable. So first, a jury must be convinced that the circumstances were such as you described them, and that is the subjective part of the test. The jury decides whether that's true or not, and then the force that you used must be objectively justified, and the jury decides that as well. So the jury has put this two-part test. Was it necessary? Was it proportionate in the circumstances that you believe them to be? Now, in this case, the jury acquitted this officer in under 3 hours. They were unanimous and resolute and decided very quickly, by all accounts. So the IOPC now looking at a misconduct hearing despite the jury acquitting him unanimously and very quickly. This, for me, raises three very important questions. Firstly, the generic question, why would the IOPC look at a misconduct hearing for something of this nature? Secondly, why would they do so given the fact that this has already been through extensive evidence? And thirdly, a more general but very serious question, how can we possibly expect our firearms officers to go out and do their job with confidence, knowing that in circumstances like this, they will not only be prosecuted for murder, but then they will also face this misconduct hearing which could ruin their career, the very thing that they've been training for many years. Now, those questions in order. The easiest of those to answer is the first one. Why would the IOPC look at a misconduct hearing about this in the first place? Well, simply put, we do need to maintain standards, and if there's information or evidence that suggests that there may be something to indicate that the officer did not act with full professionalism and fell below those standards, then the IOPC may investigate that. The second question is not so easy, and I think the Assistant Commissioner of the Met Police agrees with this assertion that I'm about to make. Given that this was so extensively deliberated in the Crown Court with extensive representations and evidence and so on, it really does stand to reason, in my view, that that should be the end of the matter, and the IOPC really should have taken lead from the jury's unanimous decision, in that this officer acted lawfully. After all, we should be trusting in the justice system, and the jury system is very much at the heart of the criminal justice system. So the second question, not so easy to answer. And as to the third question, how can we expect firearms officers to do their job knowing that they might be then prosecuted for murder and put through a misconduct investigation? Rather than give you my opinions on that directly, what I will say is that it is almost inevitable that this is going to lead to more and more firearms officers returning their authorization to use firearms in the line of duty. That is backed up by statistics. Between April and December 2023, over 250 authorised firearms officers left the Met Police Firearms Unit, which was around 10% of the armed officers of the force. This was significantly attributed to the concerns about the unit's ability to maintain operational commitments and the use of force and so on. Obviously, with the fallout of legal accountability, vis-a-vis charges for murder and then investigations for misconduct and so on. Furthermore, reportedly, the Met Police has tried to recruit new firearms officers, but instead of the typical 150 to 250 applicants, reportedly, they've only received 6 new applications. A strong indication that these officers simply don't want to carry firearms anymore, because if they do end up using them in the line of duty, many of them doubtless fear that they'll be prosecuted for murder and then investigated for misconduct. The very brief page on the IOPC website simply says that they've looked at all the evidence, considered the views of the parties, and taken the decision that this still meets the threshold in the legislation. They do say that they appreciate that the Home Office is carrying out a review on the legal test for the use of force in misconduct cases, i.e. officers using force. However, they say we need to apply the law as it currently stands. But again, given that the law as it stands has been tested, literally tried and tested by a jury, and they found that his actions were lawful, understanding that this is obviously distressing for the families involved, this in my view demonstrates that the law has been tested on this set of facts, and they unanimously acquitted this officer of this charge. There are, if you are interested and for full information, documents on the IOPC website which include an FAQs and a fact sheet and so on. They seem to be at least largely based before this decision to hold this hearing was taken, but nonetheless, they are broadly the same. They say that they've considered the evidence and they consider this separately from criminal proceedings, etc. The purpose of a misconduct hearing is to maintain public confidence and reputation of the police service, upholding high standards in policing and deterring misconduct, and to protect the public. But ironically, public confidence in the police service to do their job may be hindered if the public no longer have confidence, because the police no longer have confidence in doing their job, because they are prosecuted for their actions in the line of duty and then put through misconduct hearings following a unanimous acquittal in a Crown Court trial. So ironically, I think this is likely to dent public confidence in the police service ability to do its job rather than assist it by going through this misconduct hearing. Now again, I understand there'll be views on both sides. Some people might think that his actions were disproportionate, he shouldn't have done it, etc. On the other hand, some people believe that his actions were perfectly justified and that this is what we should expect of our police service to protect the public at large, and indeed that's what the jury found at the trial. But either way, many of you might have different thoughts. Let me know those in the comment section below. And if you want to know more about self-defense and the use of force in general, not to be a replacement for legal advice, but do check out my join button to join as a member here on YouTube, and you'll get access to those videos and many more videos that'll be custom and members only videos, which will be far more extensive than snippets of news and videos that I do here. So very much appreciate that. Thank you for watching, and I'll see you next time.